So after the discussion of provisions of 103 to 105 of the Trademarks Act 1999 in context of the part 2 of schedule 1 of CRPC, let me discuss what is the position as far as the provisions of Copyright Act is concerned. I am talking about the provisions of 63 of the Copyright Act, because the punishment related portion in provisions of 63 and in provisions of Trademark Act, that is 103 and 104, is similar. There is not at all any difference, even word to word they are similar. So under these circumstances, whether the offense pertaining to the Trademark Act and whether the offense pertaining to the Copyright Act are cognizable or not in context of the part 2 of the part 2 of schedule 1 of CRPC. Let me discuss this along with certain judgments, because the Copyright Act, now in this today's video I am going to discuss some judgment as well as the provisions of Copyright Act, and in part 1 of this video I have already discussed about the provisions of the offense or the provisions related to the offense of the Trademark Act. Copyright Act is totally silent as far as the provisions related to 115 subclause 3 of the Trademark Act is concerned. 115 subclause 3 says that the certain provisions, that is 103 to 105, is cognizable, or the offense pertaining to those sections is cognizable. Here in Trademark Act, such type of section is not at all available. I am talking about section 115 subclause 3. Such type of section is not available in Copyright Act 1957. Hence the Copyright Act is silent about the provisions that is related to section 63. Whether 63 is cognizable or not, it is not at all mentioned. However, in the Trademark Act it is mentioned that yes, at least it is mentioned that the provisions of 103 to 105 is cognizable under section 115 subclause 3, but in Copyright Act it is not at all mentioned. Now what would be the position if it is not mentioned in the statutory special statute, because Trademark Act and Copyright Act both are special statutes? So can we take the help of certain judgments? Yes, the answer is yes, we need to take. So let me discuss certain judgments. Before I go to the certain judgments or discussion of the certain judgments, I would like to draw an attention as far as section 70 of the of the Copyright Act is concerned. It says that about the section 70 of the Copyright Act says about the cognizance of the offense is taken by the Metropolitan Magistrate or a Judicial Magistrate first class to try any offense under the Copyright Act. The cognizance to be taken by that magistrate. However, this section is silent in respect of the offense. That offense is whether cognizable or not. So in my opinion, that section cannot be considered. Yes, this section is given in the Copyright Act stating that the offense is cognizable, or the copyright or the offense pertaining to the copyright is cognizable, because this section says about the cognizance to be taken by certain magistrate. In view of this discussion of my video, let me now discuss certain judgments available as far as the Honorable High Courts are concerned and Supreme Court concerned. Honorable Supreme Court, in my first judgment, I would like to invite the attention of the viewers and listeners in respect of one judgment of Honorable Supreme Court. However, it is related to section 167 subclause 2 of CRPC, but here is the why I would like to draw the attention of the viewers in respect of this judgment. The reason is the language of section 167 subclause 2 of CRPC and the language of 63 and 103 to 105 That is why my intention is whether the offense is cognizable or not, we can decide by relying upon this judgment. The judgment of Honorable Supreme Court is in the case of Rajiv Chaudhary versus State NCT Delhi, AIR 2001 SC 2369. In this judgment, two terms plays very important role. One is imprisonment for a term not less than 10 years. That is provided in provisions of section 167 subclause 2 of CRPC. And another term, that is imprisonment which may extend to 10 years. That is provided in section 386 of IPC. The issue involved in this judgment is with regard to the interpretation and construction of the expression of punishable with imprisonment for a term not less than 10 years. Not less than 10 years, occurring in Proviso A to section 167 subclause 2 of CRPC. In context of the expression imprisonment which may extend to 10 years, occurring in section 386 of IPC. Honorable Supreme Court in this judgment held that imprisonment for a term of not less than 10 years cannot be considered as imprisonment which may extend to 10 years. Both are separate, both are different. In context of this judgment, I would like to argue that not less than 3 years and for 3 years, which are depicted or which are mentioned in the concerned provisions, that is 103, 104 and 105 as far as part 2 of first schedule of CRPC, both are distinct and different. That is why I would like to draw the attention of the viewers as far as this judgment is concerned. Now, after this judgment, the second judgment is Avinash Bhosle versus Union of India 2007 14 SCC 325. Honorable Supreme Court held that an offence punishable under section 135(1) subclause 2 of the Custom Act 1962 would be bailable. The offence under this section is punishable with imprisonment for a term which may extend to 3 years or fine or both. Whereas the offence punishable under section 63 of the copyright is punishable with imprisonment which may extend to 3 years and with fine which may extend to 2 lakh. Thus, the offence under Copyright Act is bailable as far as the judgment of Honorable Supreme Court in the case of Avinash Bhosle is concerned. Because the same provision as far as the imprisonment is concerned in respect of the Act, that is Custom Act 1962 is provided, and the same provision is also provided for Copyright Act. So in the offence pertaining to the Custom Act, Honorable Supreme Court says that it is bailable, and the same ruling may be taken for considering the provisions of Copyright Act, and it says that it is bailable. Now the third judgment of Guwahati High Court. Honorable Guwahati High Court in the case of Jitendra Prasad Singh versus State of Assam in the year 2002, that is the citation is 2003 26 PTC 486 Guwahati High Court. This judgment is related to 63 of Copyright Act. Para 5 is related to the issue, and para 7 as well. The question before that Honorable High Court is whether the offence punishable under section 63 of the Copyright Act is bailable offence. Now, para 7 of that judgment says that essential to note that the expression punishable with imprisonment for a term which may extend to 3 years is distinctly different from the expression if punishable with imprisonment for less than 3 years. Inasmuch as the expression mainly punishable with imprisonment for a term which may extend to 3 years will mean that imprisonment can be for a term as long as 3 years. But the expression punishable with imprisonment for less than 3 years will mean that the offence is punishable with imprisonment for a period which is less than 3 years. Viewed from this angle, the offence under section 63 of the Copyright Act is non-bailable offence. This is the view of Honorable Guwahati High Court. In another judgment of High Court of Andhra Pradesh State, the Honorable High Court of Andhra Pradesh in the case of Amarnath Vyas versus State of AP 2007 CRI Criminal LJ 2025. This is the citation. Relying upon the judgment of Honorable Supreme Court in Rajiv Chaudhary's case in para number 12 and para number 11, Honorable High Court considered that the expression used in the second category of part 2 of Schedule 1 of Cr.P.C, that the term of imprisonment for 3 years or onwards but not less than 7 years cannot be equated with the expression used in section 63 of the Copyright Act, the imprisonment which may extend to 3 years. In para number 12, it is said that having regard to the fact that the judgments of Kerala and Guwahati High Court have not considered the judgment of Apex Court in Rajiv Chaudhary's case, with due respect, they cannot be considered as having laid down the correct position or proposition of law. Therefore, the expression imprisonment for a term which may extend up to 3 years, in my considered view, would not come squarely within the expression imprisonment for 3 years and upwards. Therefore, the offence punishable under section 63 cannot be considered as non-bailable one. Cannot be considered as non-bailable one. This is the opinion of Honorable Andhra Pradesh High Court. Now, the next judgment is of Honorable Kerala High Court in the case of Abdul Suthar versus Nodal Officer Anti-Piracy Cell AIR 2007 Kerala 215, second citation 2007 35 PTC 780 Kerala, in para number 3 and para number 7. These two paragraphs of these judgments are important in view of our today's topic of video. A plain reading para number 3 of the stipulation in the schedule shows that if the offence is punishable with imprisonment for 3 years and upwards, but not less than 7 years, it must be reckoned as cognizable. section 63 according to me is clearly punishable with imprisonment for 3 years, and in these circumstances the offence has to be held to be cognizable. This is the view of Honorable Kerala High Court. Now another judgment is of Honorable Delhi High Court 2011-46 PTC 114 Delhi in the case of Rajesh Garg versus Tata Tea Limited and another. In para number 29 and para number 30, Honorable Delhi High Court considered the offence related to Trademark and Copyright Act as cognizable offences in this judgment. Another judgment of Honorable Delhi High Court, again relying upon the Avinash Bhosle's judgment of Honorable Supreme Court, Delhi High Court in the case of State of NCT of Delhi versus Naresh Kumar Garg. Citation is of 2011-46 PTC 114 Delhi. That is, I think, is a different citation, but this case is related to Naresh Kumar Garg, and it is decided on 20 March 2013, wherein Honorable Delhi High Court opined that offence related to copyright is bailable. Relying upon the judgment of Avinash Bhosle of Honorable Supreme Court, in para number 6, these paras are very important, para number 6, para number 7, 10 and 13. 63 copyright is bailable and non-bailable. This was the issue, and it was decided that copyright is bailable. In another judgment of Honorable Rajasthan High Court Jodhpur bench in the case of Mahendra Bhatti versus State and another on 1st September 2017, Honorable High Court of Rajasthan, relying upon the ratio laid down by Honorable Supreme Court in Rajiv Chaudhary's case and in the case of Amarnath Vyas, that is of Andhra Pradesh case, Andhra Pradesh High Court case, Rajasthan High Court in para number 12 of this judgment observed that the offence punishable under section 63 and 68A, 63 and 68A of Copyright Act cannot be considered as cognizable offence. So Rajasthan High Court cannot consider in this judgment copyright, the offence pertaining to the copyright is cognizable, relying upon the Rajiv Chaudhary's case or the interpretation given by Honorable Supreme Court in Rajiv Chaudhary's case and in the case of Amarnath Vyas case. Now the next judgment is of Honorable Delhi High Court in Anurag Sanghi versus State, and it is of 2019, yes, 25th November 2019, WPCRL Criminal 3422 of 2018. Delhi High Court relied upon the judgment of Honorable Supreme Court in the case of Avinash Bhosle in para number 10. In para number 10, the interpretation of the Supreme Court in Avinash Bhosle of the term punishment which may extend to 3 years or with fine or both, which is for an offence under section 135 subclause 1 2 of the Act 1962 will fully apply in the case under 63 of the Copyright Act. The last judgment, that is of Rajasthan High Court Jodhpur bench, that is decided on 7th April 2020 in SB Criminal Miscellaneous Petition number 5128 of 2019. In this case, matter is referred to larger bench with the question of law. Would what would be the position? The question of law referred before honorable larger bench by this bench is, what would be the nature of an offence, whether cognizable or non-cognizable, for which imprisonment may extend to 3 years is provided, and no stipulation is made in the statute regarding it being cognizable or non-cognizable. Friends, this is the latest position. So uncertainty is there whether the offence pertaining to the copyright or pertaining to the trademark is cognizable or non-cognizable. Honorable various high courts have their own opinions in respect of. Some high courts say that yes, it is cognizable, some of them say yes it is non-cognizable. But relying upon the Rajesh Chaudhary's case, my personal opinion, this is my personal opinion, it says that yes, the Copyright Act, the offence pertaining to the copyright and the offence pertaining to the Trademark Act is non-cognizable. Friends, I hope you like this video. If you like this video, please don't forget to subscribe my channel, to share, and I'm always waiting for your valuable comments. Thank you very much.